Good evening and welcome. I'd like to take this opportunity to thank our platinum sponsors, PIA Law, for presenting night 2 of our 3-part webinar series. Tonight, we welcome Nick Todorovic and William Harding of McLeish, Orlando. Nick Todorovic's practice is dedicated exclusively to plaintiffs' personal injury and wrongful death cases. Consistently ranked as one of the top 10 personal injury boutique law firms by Canadian Lawyer Magazine, Lexpert ranked law firm based on extensive peer review process. McLeish Orlando is a recognized leader in wrongful death and personal injury law, exclusively representing individuals who have suffered serious personal injury or who have lost a loved one through negligence of others. Nick Todorovic first joined McLeish Orlando as a summer student in 2014. He went on to the article, and after his call to the bar in 2016, became a lawyer on Patrick Brown's team. After completing a Bachelor of Science in Chemistry and Math at Wilfrid Laurier University, Nick went on to complete his PhD in Organic Chemistry from McMaster University. His research was primarily in the areas of combating various forms of cancer and has been published in various peer-reviewed academic journals. Following his PhD, Nick went on to obtain his law degree from University of Ottawa. During law school, he was fortunate to gain valuable experience by working for a multinational law firm in the area of intellectual property, my apologies. In addition to his academics, Nick also swam for various varsity swim teams. After his own personal experience in dealing with an injury at a young age, Nick chose to pursue a legal career that would help others overcome adversity. This passion, along with his keen sense of detail for the law, has given Nick a solid professional foundation. Nick is also a member of Cycle Toronto and is active in Bike Law Canada. We also have William Harding. His practice is dedicated exclusively to plaintiffs' personal injury law and wrongful death cases. William joined McLeish Orlando as a summer student and went on to complete his articles with the firm. During this time, he assisted at a successful 3-week jury trial for a badly injured young lady. After his call to the bar in 2018, William joined Patrick Brown's team as an associate. William received honors of Bachelor's of Arts degree from the University of Guelph, majoring in criminal justice and public policy, and graduated with distinction. William earned his law degree from Queen's University. Following the wrongful death of a family member, he chose to attend law school and pursue a career as a personal injury lawyer. While studying at Queen's, William served as a volunteer caseworker at Queen's Legal Aid, helping members of the local community with their legal problems. For his legal work, William was awarded the McDougall-Watson Memorial Award for excellence in file management, hard work and commitment to the achievement and development of the goals of the Queen's Legal Aid. And as a lawyer, William has appeared at the Licensed Appeal Tribunal, the Ontario Superior Court of Justice, and the Ontario Court of Appeal. He enjoys traveling, playing hockey, spending time with family and friends. He is a member of the Ontario Trial Lawyers Association, the Ontario Bar Association, the American Association for Justice, the Advocate Society, the Canadian Bar Association, and the Law Society of Toronto. Thank you so much for coming this evening, and I will hand the floor to you.
Great. Thanks so much, Melissa.
Thank you.
And thank you for having us. We are, of course, once again, very happy to be platinum sponsors of this event. It's a great opportunity to educate on some important topics. So very, very thankful to be involved. And also thank you everyone for tuning in. I know we're all feeling a bit of the Zoom fatigue at this point. So it's great to see so many people signed in. So Nick and I are going to be talking about invisible injuries and how you can help your lawyer out. And if you bear with me here, I'm just going to get our presentation set up. Okay, so the goal here is really for us to give you an idea of how we look at a brain injury case and the approach we take to making sure that we're properly advocating as best we can for our brain injury clients and presenting properly the nature of their injury and the way it affects their life. So some of our main objectives in that would be to prove that these impairments that they're experiencing are caused by an organic injury. This can be a challenge in cases of more mild traumatic brain injury, where you maybe don't have that objective imaging present. It's also important then to prove that these impairments are permanent in nature. A common defense that you'll see is, there's no imaging, therefore that this is something that should resolve in a few months. Well, often that's not the case. And so it's important to show, for the purposes of the action and getting compensation, that this is something that is going to be permanent and continue with them at least for an extended period of time. And then in addition to proving the actual impairments, it's important to be able to articulate how this affects the function. So how it actually affects the patient's everyday life. You want to try and paint a picture, whether it's to the insurance company or eventually to a jury, that this is the way this person's life was before, and this is where they are at now because of that injury. Some common challenges that we see on a lot of these files is simply, well, they look healthy, they look okay. And this again is because often you don't have that objective injury or objective evidence of the injury. Similarly, expert reports, there's often competing expert reports. This is something that has to be dealt with. You see it frequently with neuropsychology experts as well. That's something that is often faced on every file. Again, another argument you see is there may be symptoms, so these are actually just emotional and psychological in nature, and therefore may be more easily rectified by proper treatment. This actually isn't caused by a brain injury. Again, there are a lot of tools to combat this, and I'll get into those in just a minute, but this is something that is often said by defendant insurance companies in litigation. Similarly, they love to say that plaintiffs are exaggerating or malingering. This is simply just a suggestion that they're overstating the nature of their impairments, or they're putting on a display for the purposes of the lawsuit. Again, there's lots of steps that can be taken to combat that. Likewise, pre-existing problems. It's important to make it clear that any impairments that may exist are actually caused by the brain injury and not something else that is related. So on that point, it's always important we tell our clients to acknowledge any pre-existing symptomology that may have existed and address it. And that way you're then able to kind of articulate how, okay, here's what I faced before, but here's why what I'm facing now is so different and why it affects me in this different and this greater way. And the other idea is that the plaintiff has bought into a disability. Really, this one can be dispelled simply by following the advice of medical professionals and really just doing all you can to try and get better. I find that with those efforts, it's usually pretty easy to get around that defense. Strategy. So this is essentially just a general outline of what we'll be talking about. So proving invisible injury or a brain injury, to do this most effectively requires evidence from numerous sources. It's more impactful if it's not just from one place, but numerous sources. So the ones we're going to talk about today are the patient themselves, which is an obvious one, but also their friends and family have a role to play. And finally, the medical professionals that are involved in their care. So starting with the patient, one thing that's critical is consistent, detailed reporting of symptoms. So in any action, the insurance company for the defendant is going to have access to all of the medical records. So what we want to see is the patient who, whenever they see a medical professional, they do articulate the problems that they're continuing to face. So it's not a time to be stoic or try and be, just grunt through and not talk about what's bothering you. It's very important to actually explain the issues that are ongoing. Having that consistent paper trail is going to be critical to showing that this is a prolonged and consistent issue and impairment that is a result of the injury. Similarly, it's very important to follow the advice of medical professionals. Reason being is that shows that you're, again, taking every opportunity you can to get that treatment and to try and improve yourself. And finally, I'll talk a bit about the brain injury checklist. So this is some of what I just talked about, but you want to be able to show the consistency of symptoms over an extended period of time. And having that consistent reporting combined with reports of the professionals testimony given at examination for discovery. This is all going to work to bolster the credibility of the patient. And this is important because this is a very useful tool for combating those defenses that I talked about earlier, where you're having these defense lawyers trying to suggest that maybe this isn't a severe injury or a prolonged injury. Well, if you have that long-term reporting of symptoms, that shows that this is something that is important enough to the patient that they're consistently speaking about it over a period of time. I mentioned following the recommendations of medical professionals. This is just an excerpt from a report, essentially recommending some psychotherapy. Again, this goes to what I was saying. It's important to follow these recommendations. And if a patient does get treatment over an extended period of time, then this, again, supports the suggestion that, well, clearly there are impairments ongoing, because that is why this individual continues to seek out treatment. Often you'll see, especially in cases of mild traumatic brain injury, you'll have the defense say, well, if there was any brain injury, it's mild in nature, therefore you should see symptoms resolving after 3 to 6 months. Well, if you have 2 years later and you see this person who's going for all kinds of treatment and anything they can do to try and alleviate some of their symptoms, well, that goes a long way to dispelling the suggestion that it's only a 3 or 6 month window that we're dealing with. Another really useful tool that we use in a lot of our files involving traumatic brain injury is the brain injury checklist. So it's a great tool just for screening and then documenting the existence of symptoms of traumatic brain injury. This can be completed by the patient or by a family member. So this is an example here. And as you can see, it's really just a tool to almost make you sit and address what are the changes that I'm experiencing, or what are the changes that my loved one is experiencing? Because often it might be subtle, or by nature of the traumatic brain injury, it may be difficult for you to fully appreciate the changes. So some of the ones we look at are cognitive symptoms. Here you can see, these are very common. Obviously, it varies from brain injury to brain injury, but ability to think, ability to concentrate, memory issues, understand words. Often it can be, if you have word finding issues or more trouble following conversation, it can be helpful to look at the list and say, okay, well, maybe I do have some of these symptoms ongoing as a result of the injury. The next thing we look at are emotional symptoms. Again, something that can be very common following a traumatic brain injury. This can be increased feelings of anxiety, depression, fatigue, or tiredness is also very common. And the last one is physical. Headaches, of course, are a very common symptom of a brain injury. Sensitivity to noise, sensitivity to light as well. We just find that having this list in place is very effective at the outset, for one, for stopping and looking and considering, how have I been affected, but also then doing it over a period of time, you can see how have these symptoms progressed. Are they getting better? Have they plateaued? What is the status on that? So in addition to the patient themselves, family and friends also have a role to play. Like I said, it's always better to have multiple sources of information. So the family and friends are in a position to kind of corroborate what the patient themselves are saying. Also, often, depending on the nature of the brain injury, you'll have patients who maybe aren't able to properly or fully perceive just how much they've changed. And in cases like that, having someone come in who's known the patient for an extended period of time, it's really useful to show and kind of highlight the nature of the impairments. A few things I'm going to talk about are the brain injury checklist. That one's obviously been discussed already. Witness statements, and then also a brain injury journal. So witness statements, as I said, always more impactful to have multiple individuals that can identify the changes that they've observed in the patient. It's always most effective when it's someone who's known them for an extended period of time, ideally both pre and post the subject incident causing the brain injury. Excuse me. So here's just an example here of one. This individual is a very, very high functioning individual working at the top of his career. And we spoke to a colleague of his that had been a colleague for many years. And he was able to kind of first highlight just how much of an effective employee he was pre-crash, then also give really good, really specific examples of the kind of things that he now struggled with as a result. And this is just an excerpt. He went on to give a lot of very good examples. And in things like this, examples are often key rather than just describing the symptoms or describing the impairment, to say, here is what so-and-so did before. They were the best in the field at doing this. Now, when I see them trying to do the same thing, I notice them having issue with this, this, and this. This one time at a meeting, he had an outburst with someone which would never happen before, something like that. Another really common one, this is another example, is to get it from a loved one or a family member. Here is a partner. In this case, we were dealing with a lot of emotional, a lot of psychological symptoms following the brain injury. And again, just speaking about their spouse, the kind of person they were before, the kind of things they used to do together before versus what they're like now, what kind of changes have they observed? And this is one of those cases I was talking about earlier where the spouse was actually gave much clearer evidence as far as here is what the changes have been from before and after, just again, because the patient themselves had challenges because of their brain injury. Another tool that can be used is the symptom journal. The tool here, and it depends on the case, but it can be used to track symptoms of brain injury over an extended period of time. So this is actually slightly different than the checklist. It's actually a journal, and the purpose is to focus on any symptom. It can be any symptom, headache, forgetfulness, it can be multiple symptoms, but you want to make specific detailed entries into this journal. So it can be 10 a.m. I left toast in the toaster and burnt it, or 2 p.m. I had an angry outburst over nothing, things like that. This can be completed by the patient themselves. It can also be completed by a family member of theirs. And the reason you do this is it can make a very powerful demonstrative aid. If, say, you choose a period of 2 months or a period of 6 months, and you're diligent in filling out that journal, well, what we find is with a lot of our clients is very quickly is that journal just absolutely full of entries. And so then when you're at a mediation or a pretrial or possibly in front of a jury, you can bring that in and use it as an exhibit. And it's a very powerful tool for conveying just how much a brain injury can impact someone's life when you show here is all the different times in a day where that brain injury is causing a challenge or causing an impairment. So that's something to be considered as well. Okay, so that's it as for the patient suggestions and also their family. If there's any questions about any of that so far, I'm looking at the Q&A. Otherwise, Nick will take over and talk a little bit about medical professionals. Okay, I see a question here about how frequently these reports should be made, documented with your GP. That's a great question. There's no right answer to that question. I mean, you don't have to go to an appointment just for the sake of getting this paper trail. It's more important that when you are having your regularly scheduled appointments, that you're diligent in explaining your symptoms and reporting your symptoms. So if you're in between checkups or you aren't, don't have any upcoming treatment, that's fine. It's more so that you're just consistent when you do have these appointments in answering those questions. If you haven't been journaling symptoms, that's fine. That's not something I would say, the majority of our cases where we have that from start to finish. That's something you can also do at any point in the process. So often if it's some years post subject accident, it may actually give you a better representation of what your ongoing status might be. So that might actually be a good time to do it. And it doesn't have to be, again, indefinitely. It can be, let's do a 1 month snapshot and let's pick that period of time and try journaling. Then you have that in it, and it's a tool you can use to say, look, here's a snapshot into my life. So if you haven't been doing it at this point, don't sweat it. No problem, Al. Any other questions about any of that so far? Okay, if any come up, I'm obviously happy to answer them at the end. If not, I'm going to turn it over to Nick.
Thank you, William.
Thanks, Will. I think we're just going to switch now. So I'm going to go to my share screen so I can continue on with this. Let me know if there's any problems viewing it. Does everyone see that okay? Okay, so just coming off of Will's talk, MTBIs are some of the most difficult cases to litigate from a legal perspective. There's no objective injury, there's no fracture, there is no brain bleed, there's just symptoms and subjective reporting of those symptoms. And that's where the treatment providers and the team really help build the case. We rely on you. We can only litigate the evidence that we have. We can't make up stuff. It has to be well documented. It has to be on paper. It has to be something that we can put in front of a judge or a jury to exemplify the nature and extent of their injuries and impairments. And really, we're relying on you to do that for us. We can only go so far as to make sure to remind our clients to report their symptoms, make sure they get treatment, make sure they're diligent on that. But really, it's in certain situations, it's going to be all of the treatment providers that are going to be not necessarily making or breaking the case, but really helping push this case forward and helping us advocate for the clients. Some examples, when you do have a very stoic individual that doesn't report their symptoms, or an individual that's very positive and hates talking about negative aspects of their life or their impairments, they're not saying anything to anyone about how they're doing. And they may only talk to their close family members. Well, that's a problem because on paper they look fine. And when it comes to trying to get this case to mediation or a pre-trial, we will run into massive roadblocks when we're trying to make our case, because also when it comes to our experts, where they have to take a look at the file, they're also taking a look at what's being reported as well, and they're summarizing all of the documents that they've received in order to come to their opinion and formulate their opinion. So it also is important from that perspective. And if there really isn't anything, then it just makes it that much harder for them to come to their opinion and for us to help push their case, even though when we know that they are having deficits. So from a treatment perspective, when you know that there's a client that is not vocal about their issues, it's important to tease it out of them however way you can do it based on individual. It's also very important to have an idea of what issues are really in play for that particular person. If it's someone that really that's with a mild traumatic brain injury, they may require some level of attendant care, but that's generally always going to be hotly disputed by the other side. So it's important to know that if they do need some level of attendant care, to be able to document what type of attendant care needs they would require and why, and what are those examples. And using real world examples is very important, because let's say when these individuals are going to a defense med or an IE, they're not put in real world situations. They're literally going to be seen for an hour, maybe two, and then they're going to put together a very quick report saying that they're fine because they could do these little tests here and there. So it's very easy for them to write off the person as they're fine if there's not really, if the issues that we're going to be disputing are not very well documented. And in certain situations, people want to return to work, even though they may not be well enough to do so, but they obviously want to move on with their lives. They don't want to be stuck feeling like they're disabled, and they want to get back to their normal life. So in certain situations, you have to almost anticipate that they may not be able to return to work and they're overextending themselves. There may be a failed return to work. More so from an occupational therapy perspective, it's important to document how they're doing on any return to some type of employment or whatever the case may be. Not with the hope that it's not that you're looking at it with the lens that they're going to fail, but what if that happens? What were their problems? Why are they not succeeding? That's all important information to have in order to be able to convince the other side that yes, this person is not making things up. They're not exaggerating. They have a real world problem. They have a real issue. And although you can't see it, it's still there. One other aspect that is, I find also important, involves children, where everyone just assumes that kids, because they're young and they're developing, they can bounce back from almost anything. It's not true. It actually, although it seems like they come to a recovery a little bit faster, from a brain injury perspective, if it's not objective, if it's a mild traumatic brain injury where there is no imaging, you're not going to see deficits in certain ages because they don't have to use those higher executive functions. So it may not show itself for years, where you have to it's either a waiting game, or you have to be even more diligent in understanding what symptoms and impairments to be looking for those age groups, because it could be buried in something very minimal that you otherwise wouldn't be paying attention to. Those help go a long way for younger children, where it may not be as readily apparent. And like I said, all of this information we need to rely on if this matter ever goes to trial, but we even certainly have to rely on it when it gets to a mediation or a pretrial, because those are key events in any litigation where we're trying to get this resolved for that individual, because the faster you get it done, the better it is for them at the end of the day. So how do we do that? Well, it's also making sure that we tell our treatment providers and any experts the best way to draft reports. This part of it will be for treating, part of it will be for experts and what to include in expert reports. Some of you may not ever be used as an expert, but either way, there's still helpful tips to know in order to make sure that your reports and progress reports and even expert reports are as best as they possibly can be. So your clinical notes and records are always going to be asked for, no matter what. They're always going to be asked for, and so it's very important to be mindful about documenting your client's issues and impairments and problems across the entire spectrum of their life. The paper trail is going to be what the defense are looking at in order to attack your case as well. The smaller it is, the less it's being reported, the more it's going to be thrown in the client's face when they're trying to say that they're actually having problems. So it's going to be something that everyone is looking at, and they're going to be looking at it, especially with defense, through a magnifying glass and picking through it with a fine-tooth comb. And it's true, it's a chronology from the start to finish of their injury up until the end of litigation, whatever the case may be on that front. they're going to be looking at that to determine every single stage, at what point are they resolving certain issues, and at other points, what's either plateauing or getting worse. Generally, things don't get worse, they generally get better, but it'll get to a point where they're no longer recovering. And why is that? That's why it's very important to be consistent, like Will said, in making sure that they're reporting all of their symptoms and impairments, and that they're not jumping back and forth in terms of how they're saying it. So consistency is very important. And like I said, it is going to be the blueprint in terms of the overall picture of how they're like and how they're functioning now and how they may function later, and what are the key, how it impacts them in key aspects of their life. And in certain situations, depending on the type of treatment provider you are, you'd be documenting not only the treatment that you're engaging in, but also other aspects of treatment that they're involved in. So it's also very good to make sure that you're honing in on the specific treatment that's working, the other stuff that may not be working. And this is really what's going to help us be able to, especially from a future care perspective, make sure that we can maximize the money that we can get them for treatment going into the future. Because I can tell you, based on my experience, defense and insurance companies from a tort perspective do not like paying a lot for treatment, for future treatment. They just generally don't do it, and juries generally don't award a lot for it. It has, because they don't see it as strong as maybe an economic loss claim or something like that, unless it's in the most obvious cases like quadriplegia, paraplegia, losing limbs, that type of thing. So that's why it's even more important to document it as best as possible, because especially from a future care expert perspective, they can only make the recommendations that are well documented in the file. So in terms of putting together reports, there are a few things to be mindful of, and I'm sure most of you probably already know this, but it's always good to have a refresher, is try to avoid any discussions between legal counsel and the client. Number one, it's privileged. The clients sometimes don't even realize that, and they just say, my lawyer said this, my lawyer said that, or they discussions with where the file is at, their tort file or their AB file, or you want to be as objective as possible and try not to involve the legal aspect of it as best you can. Now, obviously, it's unavoidable in certain situations because it's a lawsuit is a very stressful thing for a patient and a client, and it does impact their life, for psychologically, emotionally, all of it, and they do want to be able to talk to someone about it, and it does impact them, especially if it's a big psych case. It's best, though, from our perspective, to, if you can, leave it out. But if it's something that's completely consuming the individual, it's really a case-by-case basis. But the general rule of thumb is don't involve it. Now, another thing is, obviously everyone wants to look on the bright side because it's just the better thing to do when you're involved in a situation like this. And it's better for the individual so that they can help move on. That being said, when you're including it in a report and you're including third-party information from family members, talking about their recovery and how they're doing, you got to also make sure to be as objective as possible on this, on how they are actually doing, and leave out opinions from friends, family members, even the client, some situations where they may not even have an understanding of how bad it actually is. And although they're looking, they think they're improving, on paper they're really not. So it's best to leave that kind of stuff off the paper, and you can chat about it with them, but really it's better to not include it. Another big one, avoid the strong language unless it's absolutely true. One of our number one concerns is maintaining the credibility of our clients. This is even more so the case when you're dealing with non-objective injuries like a mild traumatic brain injury, where their credibility, where most of the case is going to be made not only from obviously the clinical notes and records and progress reports, but also on their subjective reporting and what they're telling everyone. And these individuals are constantly poked and prodded in terms of talking about their deficits over and over again, and maintaining a consistent reporting of symptoms is important for credibility. But also, when writing your reports, if you use stronger language when talking about what they can or can't do, and the insurance company does surveillance on them and finds out that they do it even once when never was used, or can is used, or all the time, or whatever the case may be, all they have to do is find one instance where that's not true, and their credibility will be attacked. Another thing to be mindful of is to ask the right question in terms of being able to highlight their deficits, where, like these examples, can do, cannot do, trying to do, can do with pain. The way to get to the answers that will best highlight their deficits is not to try to get them to one-word answers. Yes or no, where it's, can I mow the lawn? Have you mowed the lawn since the accident? Yes. Okay, well, have you tried mowing the lawn? How's that been? Opens it up for them to explain things rather than puts them in a box of a yes or no where they can't. And here's an example of it. Mary, can you shovel snow? Answer, no. Then the report will just show can't shovel snow. The right way, or the preferable way to do it, is, Mary, have you shoveled snow, and what were the results? Mary, I tried to do the walkway for about 10 minutes and I had to stop because of back pain. Answer in the report, Mary tried shoveling snow but could not continue due to pain. Being able to ask the right questions to allow the person to provide you the fullest answer possible is great. In most cases, people don't even think to provide you with more information because they just don't know this process. Any injured individual has no idea that this is even important information. So that's why we're relying on you to make sure that you're also asking the right questions in order to properly, in order to get the best report possible on how they're doing and give the biggest snapshot of their life for us. Now, apart from the progress reports from treatment providers, some of you maybe might be experts at some point as well. And we get a variety of experts. It's very important for us in order to build our case and get settlement of these cases. And they're not like treatment reports. They do have to provide an opinion, and it has to be within their expertise. And they can only provide the evidence, like I said, on the opinion of that area of their expertise. So few things to remember is, don't be an advocate, leave that to us. We just need an opinion so that we can then advocate for the client based on those opinions. And same goes with treating progress reports as well. Don't be an advocate. Be as objective as possible in terms of giving us the evidence that we need to do that heavy lifting. And how do the courts view that with anyone that tries to advocate? Is that they're viewed as less credible and biased, and in certain situations, they could be kicked from providing evidence, which is a big problem for us if it ever gets to that point. So the key thing for everyone is keep the language neutral and unbiased at all times. And even in some cases, some experts, if they have to respond to a defense report, they can get quite heated based on what the defense expert is saying about their report. So it is another thing where you have to stay neutral and unbiased throughout the whole process. And in terms of the expert reports, the rules are quite clear. It's got to be fair, objective, nonpartisan, and they can only be within the expertise of that individual. Okay. In certain situations, the courts do allow for, I guess, treating experts to provide evidence as well. It's a little different than providing expert evidence for the purpose of a specific opinion where you're not treating, but I'm not going to get too deep into that at this stage. Giving examples of deficits in reports, just like Will has said, examples and stories will go a very long way to help highlight the nature and extent, especially of a traumatic brain injury. Reeling in stories of where they've tried to do something and it's failed. Getting examples from family members. A traumatic brain injury can span the whole spectrum of cognitive function, psychological issues, emotional issues, problems between family members and friends, big ones with spouses and behavioral changes as well. If there are memory issues, the people that know about the memory issues are not the person that's injured. It's going to be the other third parties, collateral evidence from family members that are going to say, they always forget this. They always forget that. I'm always repeating this. I'm always repeating that. That's where you're going to get some of the very good examples of deficits, because most of the time, well, not most of the time, but some of the time, have no insight as to how injured they are, and they have no comprehension of that they're actually, those issues are actually issues. And like I said, someone who has a memory problem has no idea what they're forgetting in some situations. Providing a complete and pre-collision history. Sorry, I'll go back. Like Will said, one of the defenses is that, yeah, you've had a few concussions in the past, or you've knocked your head a couple times in the past. That must be this. And it has nothing to do with what happened to you in that collision or that slip and fall or whatever the case may be. Making sure that you're well aware of their pre-accident health history is also important for creating a complete profile of these individuals. By knowing what happened to them in the past, what their symptomology was, and how their recovery was, and also documenting how functional they were at the time before the collision happened, will go a long way in dispelling all of that defense of a pre-existing health issue that is just simply making its way through. and it has nothing to do with the intervening collision. So that's also very important to have a clear understanding of their pre-accident health history to help with identifying the new issues as well that are cropping through that weren't an issue before. And especially it's a very important thing to be documenting when it's someone that did have a pre-existing health issue, such as concussions, but they were getting better and they were actually anticipating going back to work or getting back into whatever, and then the collision happens, they get a new head injury, and it all goes downhill from there. And like I said before, consistency of symptoms and complaints, it goes to credibility. They're going to attack credibility at every chance they get, and the symptoms and complaints are always going to be the easy one for them. It's the low-hanging fruit. It's as simple as creating a chart for a defense counsel on what they're saying when. So it's very important to keep it consistent. Again, strong language, weak language in reports when it comes to opinions may not be as applicable here, but either way, using stronger language on opinions is different than staying away from strong language when you're talking about what their deficits are as a treating report. In an expert report, you want to stay away from weak language, which is possibly, might, may, at risk for. It's got to be likely or probably, because we have to work on a balance of probabilities, which is more than 51%, or 51%, more than 50%. And we have to be the ones that establish that. So it's probable versus possible. And you got to know when to use each one. Usually we will be involved in helping with that and guiding when we get these reports. But it's also very important to understand what the issues are in play for these individuals from a treating perspective, especially from accident benefits perspective. You might have non-earners, you might have IRBs, you might have attendant care, or whatever the case may be. Knowing the tests, knowing how to incorporate those opinions to fit those tests is also very important. And that's, and I'm not sure what this slide is, but that's it for me. So thanks everyone. Thanks so much for inviting us. And I'm happy to answer any questions.
Thank you, Nick. So I have two questions that kind of came up. One of them, a member asks, besides trauma from the accident, what about the chronic stress that exacerbates your brain injury symptoms from dealing with the insurance companies? Constant gaslighting, making you feel as if it was your fault when it wasn't.
I mean, that all kind of, you want to make sure that you're staying on topic of the issue. And the issue is the person has suffered a traumatic brain injury. And you're documenting the brain injury. Obviously, there's going to be external stressors, like number one, just being involved in a collision is traumatic enough. Number two, being involved with lawyers, that's the worst. So it creates these stressors on individuals, apart from also getting IEs that say you're fine and you should be moving on with your life. But the key is to make sure that these are stressors that are probably wouldn't have been a stress had they not had the injury. And you want to make sure to separate the external from the internal and be able to comment on what's happening internally and how they're dealing with the external, which is also very important. Some people may not have the ability to cope with the stressors anymore like they normally could. They get completely overwhelmed by something that would have been very straightforward. So it's number one, have a well-documented internal symptomology, subjective to the person, and then try to translate that into how they're reacting to the external.
My apologies, I was muted. The next question is, often with brain injury, the symptoms experienced by a patient can shift, better for 1-2 months, and then they get bad again. How does that affect credibility? And wanted to add, how can the patient, let me scroll down, maintain credibility with those changes?
Yeah, in some situations, it's a wax and wane in terms of symptomology. Some things, in some situations, they're better. In some situations, they're worse. Like I said, again, it's very important to understand where it's coming from. Is it a student who's returning to school and the stressors of exams or tests are what really set them off? And let's say during the summertime, they're fine. Well, then you're not really going to have as much symptomology. Or let's say someone's working and they have to go off work, or they're pushing themselves at work and their symptoms are exploding and they're constantly fatigued. And although they can maintain their personal life as a disaster, well, then they go on a vacation for 2 weeks and they feel incredible. It's because they're not using their brain. Document those based on if there is an external force that's causing it. Find the source of what's causing those issues, and that way you can maintain the credibility, because it's just, let's say they go back to work or they go back to school and all of a sudden they flare up again. That's why it's so important to understand what situations are causing what symptoms. It may not be as readily apparent, but there's something there generally.
I think you're just muted, Melissa.
I did. I hope that answered your question. Thank you so much. I don't see any more questions coming in, so I'm just going to take the moment to, the member has said thank you. I'm going to take a moment just to give another minute. If anyone does have any more questions, feel free to type them, and I'll ensure that our lawyers can answer your questions. And if not, then we'll end up ending the meeting early. So if there are any questions, let's see if we can get those answered. And if not, then, as you know, we'll be meeting again on Monday next week for another and final webinar. Okay, so there's no more questions for tonight. I wanted to once again thank the PIA Law, our platinum sponsors, for putting together this webinar series. Again, I want to thank Mr. Harding and Mr. Todorovic from McLeish Orlando for coming by and delivering an amazing presentation. Oh, there is a member who has one more question. Oh my goodness. So for the member who just came in and said they have a question, go ahead and quickly type it in. I'm going to go on to the next question, and you'll have time to ask your question before we end for the evening. There is a question that says, what are the top 2 things we should focus on or avoid that can make a stronger case?
Well, you can take that one.
Sure, I can touch on that. So, I mean, it might be tough just to narrow it down to 2 things, but I think Nick touched on it. Your credibility is everything in a lawsuit, and so that can apply to many different parts of it. So the one thing we talked about was your pre-accident history. If you do have a prior concussion, don't be afraid of that. Be open and honest about it. That should be your rule of thumb, is be open and honest. And so that means fully explaining your symptoms, but also acknowledging things that may have happened before. That can be worked with. You can clearly explain, yeah, I did have this setback. I actually needed some treatment before this crash from my previous concussion. But at the time of the subject accident, I was able to do my job. I was able to do the chores around my house. I was able to cut my lawn. Now I'm not able to do that. So rule of thumb is be honest. Don't try and be sneaky and try and, think of things that you need to hide. Open and honest is definitely a good thing to remember. I think the other thing really is just trying as best you can to be consistent with your reporting. And that again kind of ties in with credibility, but having those consistent records throughout the lawsuit is going to go a long way to kind of showing that this is something that is important to you in terms of it has that effect on your life. And therefore, regardless if there was positive imaging or not, or regardless if there's a defense expert saying you should have recovered after 6 months, the fact that you're reporting your symptoms, going to get treatment, that shows that very clearly this is something that's affected you and you're still trying to make efforts to get back on track.
Perfect. And the other question is, what if an injury occurs after a car collision, minor head bang, before your claim has been completed?
So we have that happen from time to time where someone gets involved in a car accident, they get a head injury, whatever the case may be, and then they get into a subsequent car accident while the litigation is ongoing. It happens. The key thing is to document how you're doing. If it's a situation where it exacerbates your symptoms for a period of time, but then you drop right back down to your normal pre-second collision baseline, probably nothing needs to be done. And we focus on the initial injury. If, on the other hand, you suffer a new injury or your symptoms are completely off the charts and they're not going back down, different considerations have to be taken into place where we might have to initiate a second claim and get another accident benefits claim going as well.
Okay. The next question is, if you do have a fracture and a brain bleed, is that considered a moderate or severe TBI? And thank you.
Well, you can take that one.
That's a double check, but I believe that is a moderate TBI. It would depend on a couple of other things, your Glasgow Coma Scale, loss of consciousness as well. You'll see that often debated amongst the experts as well. And it is helpful to have that classification, but in my experience, it is the nature of the impairment is going to drive everything. So you'll see people who will have that classification of a moderate or sometimes even a severe, and they may have a fantastic recovery to the point of almost full recovery, versus you'll have someone who didn't even suffer a loss of consciousness, maybe didn't start experiencing symptoms until a week later, and for years they'll be plagued with memory issues, chronic headaches, things like that. So as much as that distinction is important, it's ultimately the effect it has on function and the nature and long-term impairments that come into play.
Thank you. That was a great question. Okay, so once again, I'm going to give it about 1 minute, and then if there is nothing, then we will say goodbye for the evening. I also want to take a moment and thank all of our members for attending tonight and for participating. There were some really great questions. Sometimes when people are thinking of a question, it's not always easy to step up and ask that question. So sometimes when you ask a question, it might be one that other members have as well, and they're just not as comfortable with participating. So thank you to everybody for participating and asking questions and imparting even additional knowledge due to some of the nature of your questions. Okay, we have one more. What about if the accident happened out of province, in a different province?
Yeah, I could comment on that. There are a couple implications. With respect to a civil lawsuit, it can still be brought. It would have to be brought in that jurisdiction if it happened out of province. But if you do own a car and have your own insurance policy, there's a mechanism in play. It's called an OPCF 44R policy, where you can claim through your own insurance company in the event there is some insurance lacking. So if it's out of province and in the States, in all likelihood, there's going to be significantly less insurance in play. Often we're seeing cases of only $50,000 in liability coverage, whereas up here we usually have $1 million or $2 million in limits. So absolutely, if you have been injured elsewhere, you can absolutely still seek compensation for those injuries.
Thank you. It's been very dynamic tonight, so I almost don't want to jump the gun too soon.
Some good questions.
Yes. Even I'm learning some new things. Okay, so I think we're going to end it. Again, I want to just thank PIA Law. I want to thank Nick Todorovic and William Harding from McLeish Orlando for coming in tonight. And thank you to all of our members for attending tonight. And once again, just let you know, this will be recorded and put up on our website and our YouTube channel. And we'll see you next Monday. Thank you.
Thank you for having us.
Thanks
Take
for
care.
having us.
Thank you.
Take care.